Welcome to the Property Management Law Solutions Podcast. Your host, Attorney Tim Baldwin, will guide you in all things property management, law, markets, politics, and commentary. Your property is his priority. Here's your host, Attorney Tim Baldwin.
Hello, everybody. Welcome to the Property Management Law Solutions Podcast. I am your host, Attorney Tim Baldwin, and we have a guest today that I know you're going to really enjoy. His name is Peter Sobota, and he is an attorney in Florida along with myself, but he's on the south end of Florida, as I am on the north end of Florida. So we've never met each other in person, but we have gotten to know each other a little bit, and I think he's going to be a great person for this show to listen to. So, Peter, thank you for joining us today.
Oh, thanks for having me, Tim. My name is Pete Sobota. My practice is down here in South Florida. I pretty much I'm a solo practitioner. I have a broad practice, but my focus is on really aviation work. I'm board certified as an aviation attorney. But, being a solo practitioner, you do a little bit of everything. And one of the things I do for my clients is some landlord-tenant work, either lease agreements, or in the case of what we're about to talk about, speak about is an eviction. So,
yeah, it's interesting. There's not a lot of people, not a lot of attorneys that I know of, at least, that do those other things. Aviation law, that's pretty awesome. Do you fly as well, Pete?
I do, yes. My undergrad is from Embry-Riddle in professional aeronautics. I've been a private pilot since probably 1983 or so.
Wow.
And do a lot of flying just for myself. I'm also when I went through the Embry-Riddle program, I had my commercial, instrument rated, I did all those things. And then that's really what led to my passion to be an aviation attorney as well and get board certified in that area.
Nice. That's very cool. Well, so you have the pleasure of handling landlord-tenant cases every now and then. And yes, we're going to delve into a case because this is actually how I learned of you, Pete.
Okay.
Was through a case because I follow the case law updates. I get notified when there's a new published case, so I read all these cases, and lo and behold, your case came up, and I was just it's one of those cases that just really get your attention because you see just how sideways these cases can go. And this is one of them. So for the folks who are listening, kind of buckle up and let's listen to this story that Pete and I are going to develop for you because really it just, I think, goes to show you, first of all, some of the risk that landlords have in this business. And also, the judicial system, doesn't always, sort of live up to what you might expect or hope in your case. And things happen, depending on the judge, depending on the defendant or the tenant that you're suing. A lot of different factors go into it. So let's kind of get into this case, Pete. So this was in Broward County, right?
Right. Yeah. This was a case. The landlord has a 6-unit building down in Hollywood, and this was the eviction of one of the units. It was a gentleman and his wife that were being evicted. They had been tenants in the building as month-to-month tenants for many years, and in the last year, there was a back and forth about wanting them to leave, and they had asked for a 1-year lease and agreed that at the end of the lease, December 31st, they would voluntarily just move out and return possession to the landlord. So the landlord agreed to it. It was like the landlord was actually very accommodating for these tenants. She felt bad for them. They were generally a lower income couple. The husband had several felonies, and he'd been in and out of jail. And the landlord, really felt bad for them and wanted to try to help them out and would let them stay till the end of the year. That was in 2023. So that was really setting up where this was going. When they got near the end of their 1-year lease, there was a little bit of a flurry where the landlord had found that the tenant was trying to rebuild a car in the parking lot of the apartment building. It was up on jack stands and had parts missing, apparently. And she had sent them a correspondence saying, look, you can't have this car in the parking lot. It's causing, I'm getting letters from, as a code violation, you can't have a junk car up on jack stands in the parking lot. And that's what kicked off the tenants decided to use that as a sort of a reason to start fighting this eviction. And they immediately fought back, and they said, we're gonna sue you, you're just racist, and they tried to turn it into, I should say the tenants were African American couple, and the landlord is white, but the building was pretty much, of the 6 units, 3 were occupied by African American couples, and the other 3 were occupied by, Latin people. So it was like, there really wasn't a racial or a ethnic component. She was very fair with them.
Yeah.
And that's really where things started going off the rails. It started there. And what the tenants did was they immediately went out and filed a housing complaint saying that we're being wrongfully evicted. It's a retaliation for us not moving our car out of the parking lot. And they filed a lawsuit against the landlord demanding $70 million, saying she's a racist and this is all unlawful eviction.
Yep.
So that's what started this thing off, and that was late in 2023. We let them finish out their lease. We didn't take any action until January 1st of 2024 when they refused to leave, and I filed a very basic eviction suit, saying that they overstayed their lease and they needed to get out.
Let me pause you right there, because this is, as the listeners are going to see, the way this case unfolds. First of all, that you filed the action January 1st, 2024. Here we are now. It's in June 2025, and I'm looking at the docket on this case, and it's like you just now have sort of resolved, I think, probably your last issues in that case. Is that right?
Well, the last issue in the case was earlier this year. We got a judgment awarding fees and costs for the eviction. And that judgment's in there. I don't know the exact amount, but it's just upwards of $20,000 for the fees and costs of this, what should be a very simple, summary procedure eviction.
Right. A year passed. Fees were probably way more than what the landlord wanted to pay for a simple holdover. And, for folks who are listening who are in the business, and Pete, as you well know, holdover is one of the most simple evictions you can file. It's like, here was the notice that we're not renewing, the lease term ended, you don't have permission to be here, and you didn't leave. That's a holdover.
Sure. And to make it what should be even simpler was that the tenants did not put money in the registry within the 5 business days they were required to do that. And so even if it wasn't a holdover situation, the statute says game over, you have no defenses, and the landlord's entitled to immediate possession without further notice or hearing.
Right.
So that's where we were early in January of 2024. And, I would say I'm citing the 4th DCA, which this eventually went up on appeal, but they said the judge should have immediately issued a writ of possession at that time, and he didn't do it, and that was an error. And that's not me just saying that. That's the 4th DCA saying that.
How long did it take the DCA? How long did it take the DCA to reach that, publish that opinion?
It was, we filed the appeal, I think in March or so of 2024. The decision came out in the summer. It took them about 3 or 4 months to reach that decision. But until they issue a mandate returning jurisdiction to the trial court, you can't enforce that decision. So what happened was the tenant started challenging the 4th DCA and saying he wanted a rehearing. And every time a motion is filed with the 4th DCA, that motion has to be resolved before they'll issue their mandate. So it was just one delay after the next. The mandate should have come out, I believe, in 15 days after the decision, around 15 days. And it wasn't until October when the mandate was actually issued because of the delays in, this was a very, a unique tenant where this tenant, the husband, was definitely getting some guidance from some playbook of how to delay case, how to extend the case. He just repeatedly filed things that were literally copy and paste off the internet. He would find something from another state and he'd copy it and paste it and file it. And the courts would take it and have to process it and have to deal with it. And I think he knew that. And it just kept kicking the can down the road and wouldn't get us to a writ of possession is what we needed.
I've had those kinds of tenants before, and they do know what they're doing. They do. Right now they're using AI. I mean, AI is the source they're using for the most part, which are really helping them phrase these sort of words. So let's get this down. So let's get this down the road. I also want to ask you, actually, Pete. Was there ever either a motion or an order regarding the tenants posting bond during appeal if they're going to keep possession of the property?
Yes. What the trial court did was after the trial court refused to enter an immediate writ of possession, the judge entered an order for the tenants to deposit the rent into the court registry. And they were already behind. They had missed the original, deadline to get the money in the court registry. Yep. And then they started playing catch up and they started putting money in at that time.
All right. So they had to put the money in while they were appealing, which is supposed to safeguard the landlord, but ultimately, the landlord's wanting possession back, so it doesn't really get them to where they want to be. All right. So let's kind of move this down the road. So the fourth DCA basically said, the trial court, you should have ordered the tenants to, or should have enforced 83.60 subsection 2. He didn't. You got a mandate to remove them. What happened after that?
It was interesting. By that time, the tenants had moved to disqualify the judge, the original judge, and he recused himself. And another judge, county court judge, had taken over the case. It came back from the 4th DCA. The mandate was issued and said, the landlord was entitled to an immediate writ of possession. It should have been entered. So they entered their final ruling saying that was the outcome of the case. That's what needs to happen. And it got sent back to the county court, and the county court judge said, I'm going to have to set a hearing on this. And I was just, I couldn't believe it. I said, well, this is a mandate from the 4th DCA telling the judge what to do. The judge would not immediately enter a writ of possession still. I had to go back to the 4th DCA and file a motion for them to compel the trial court to comply with their mandate, which is really an unusual step to have to take.
Wow.
And they did. They turned that around very quickly and told the trial judge, you need to do this. You need to do what we're telling you to do. And we still had a hearing because the hearing was coming up within like a day or so. So the judge just let the hearing go forward. And at the hearing, the judge entered the writ of possession and had that issued, and that's when they finally, we got the tenants out of the unit.
So this is where the mandate came down from 4th DCA. I would imagine the tenants filed something to stay it, right? They filed something to stop it.
Well, what they did was they filed another lawsuit with the Supreme Court, a discretionary jurisdiction case, saying that the 4th DCA wasn't following Florida law. There was a discrepancy, amongst the districts, and they filed with the Florida Supreme Court. Now that was really surprising how that proceeded, because when you have a petition for discretionary jurisdiction, there's a very short time frame for the petitioner to file their initial brief telling the court, why should we have jurisdiction over this matter? That period is about 10 days. The tenants missed that deadline. The Florida Supreme Court came back a few days after that and said, hey, you missed the deadline. Here's another period of time in which to file. They filed something. It was non-compliant. The Florida Supreme Court came back and said, hey, that wasn't compliant. Here's another period of time to try again. And I just couldn't believe that was happening at our state's highest court. And eventually, the Florida Supreme Court provided the tenants with a template and said, here, just fill this out. This is the template you need to follow to file your initial brief on jurisdiction. And that was filed. I had to respond to it, and that came back. They denied jurisdiction. But that was a whole nother level of, the tenants just taking this to the extreme,
Yeah.
and the court system having to deal with it. You know,
It's just unreal. I mean, this is one reason why, and I know you've had this conversation with people. It's like people who say, well, they say the system's broken, things along that line. And it's hard to respond in a way that gets people to understand process the way it's supposed to be. But when you look at a case like this, you can really understand how they think, well, how in the world can a case like this become this convoluted, this much waste of time and resources? How do you respond to something like that when you talk to people in a case like this?
it's just, I think you said it right. It's really just it's a breakdown of the system. Our system is not really well designed to efficiently handle a tenant like this. You have, in this case, you have a tenant who is filing all these things as indigent. See, like the dynamic here was the wife has a very good job and probably makes in the $80,000 to $90,000 a year range. And the husband doesn't work, convicted felon, doesn't hold a job. And he's the one that was the catalyst behind all this. So he was filing things saying, I'm indigent, I don't have to pay for anything.
Yeah.
And meanwhile, his wife is making, good money. I think the indigency law right there, there's a section on that form that says, does your spouse work? How much money does your spouse make? And he would just leave that blank or say, I don't know. And the clerk of the court would just rubber stamp it and say, okay, you're indigent. You don't have to pay for any of these filing fees. He didn't have to pay for service of process. He didn't have to pay for the appellate fees, preparing the appellate records. It was all free.
Yeah.
So at the end of the day, when they finally were thrown out and I have a fee judgment against them, the wife filed bankruptcy saying, so it's like, they work the system, and the system does, the example I give people is this. I say, it's like giving a young child the keys to a bulldozer on Main Street and saying, here you go, start it up, and you push this lever and let it go.
Yeah.
And that in the example, the bulldozer is our legal system. You don't have to really have any skill or knowledge to work the legal system, but you can employ that system for you like these tenants did for free if you claim you're indigent. And that system has to deal with you. And no matter how ridiculous the things you file are, no matter how far off they are, the system bends over backwards for pro se litigants, even when they're abusing the system. There's no distinction.
I've seen this so many times. And all the things that you dealt with here, I've dealt with before, but not on the longevity scale like you have. Like this case almost like had all problems that we would see wrapped into one case for this period of time. I mean, on every level.
Yeah.
And so this is why there's such a case illustration of the potential problems that landlords have. So here's me. I want to try to get to some tips or some advice for landlords. I say advice. This is not legal advice. This is just a show, right? But, something for landlords to think about, because who wants to deal with this? Nobody. So from your experience, Pete, on this side of it, what do you think could possibly have been a preventative measure that the landlords could have taken earlier on, if anything?
Probably the most important thing is knowing who you're letting in your property. I mean, I think that has got to be the single most important thing a landlord could do is know who they're dealing with, know their background, you could stop things like this by just not wanting to rent to someone who has a history, a bad history, or questionable financial position. I think there's things that the landlord can do to vet their potential tenants and make sure they're dealing with someone who's reputable. And once you let someone in the property, the landlord is in a position where fill in the blank. They're the next defendant in some housing claim or some unfair, it just, and even all those things are also free. They're free to a tenant that wants to use the system. And as a landlord, you have to defend it. You have to spend money. You have to hire counsel, to help you with it. So in this case, I don't know, once the landlord was in the position she was in with having these tenants in her property, I don't know what could have been done that was any different, really.
Game over. Game over.
Yeah.
As soon as they got let in, this was just ripe for the picking for this tenant. I mean, they clearly, I don't know if this person had done this before, but this looks like a person who had some pretty good experience in the system some way, somehow in the past. Obviously you talk about, the felony conviction, and many times those types of, I say the people in those situations will do a lot of research on their own, either whether they're representing themselves sometimes or trying to help their attorney. So that could have been part of it. But as you say, your client was trying to do something nice for these people. And as they say, no good deed goes unpunished. And that's what clearly happened here. And so, when we look at this, other than the screening aspect of this, and I think you could be right about this. I think there may be nothing that could have been done. What do you think? What do you see as maybe some answers in the legal system that could help prevent vexatious litigation? This is vexatious litigation, right?
Yeah.
How do we stop that? How do you think we stop that?
Well, start from the beginning as far as following up on the what the landlord can do. I would say it starts with a very well drafted lease and not straying from as soon as a lease provision is violated or there's a problem, I think it needs to be well documented. A letter needs to go out to the tenant, because in this case, the tenant may be sending a text or an email saying, hey, you need to, clean up that car. I think if that would have been maybe in a letter from an attorney saying, look, according to the lease provision, you're violating this, you're violating that, that would make it harder for the tenant to come back and say, you're just being, unfair to us or something. I think the landlord needs to remember it's a business and stick to the terms of the lease. No matter how friendly you want to be with the tenant, you could be nice, you could be polite, but business is business and you need to stick to the terms. Now, as far as the legal system, I think the only real answer is some fundamental change in how the legal system and how judges are taught to handle pro se litigants. And there has to be, and the law says they should be held to the same standard as a reasonably competent attorney. And in my experience, that's not the case. It's just that there's a real bending over backwards for pro se litigants. And that's great in certain instances where it's justified, where someone is really legitimately trying to just figure out what to do. But when someone is on a roll to just abuse the system and that's not caught and it's just allowed to just they run rampant, in the legal system, the only thing that we could do is we'd have to rely on our judges to reel that in. And in the eviction case and in the subsequent case that came up after the eviction that we haven't even talked about is where, me as counsel was now, this person decided to sue me and sue, saying it was a wrongful eviction and all this. And
I've been there before, Pete. I've been there before.
Yeah. In two of the cases, the judges did enter orders barring the pro se litigant from filing anything else without it being signed by an attorney who's a member of the bar in good standing. And that's in two cases right now. And the tenant has appealed both of those rulings to the fourth now.
Wow. Just never ends. A gift that keeps on giving.
Yeah, it does. And, at the end of the day, you could say, well, the court system awards you a judgment for all of your fees and costs. And in this case, there's the bankruptcy process to just avoid it.
Yeah.
And, the tenant, like you said, I think at one point you said the landlord, it could wipe out, several years of rental income with one bad experience like this.
Yeah.
So really the lesson is vet your tenants, have a lease that's very well drafted and stick to it. Stick to the lease. If there's a violation, you have to send out a notice, you have to document it, and it will help you to defend against a claim that you're just being, racist, you're being, you're singling out these tenants when, you have a history of, this is how I run my building, very tight. I run my leases, whatever it is, tight. You stick to the lease, and you have to not, you give the tenant an inch, and that's where it starts to go wrong, I think. So you have to stay on top of it. Yeah.
I've preached that message time and time and time again about the lease is so vitally important. In lease enforcement is so vitally important, and not giving exceptions, or leniency for some and not for others. It's like, no, you got to be uniform, you got to be consistent, you got to enforce it and document it well. And you're right. If you need to bring in an attorney to help, first of all, add a layer of protection between you and the tenant, or professionalism, or the fact that maybe most tenants are going to take you more seriously. So all those are great points, and I've said it many, many times before. So I'm glad there's another attorney out there that confirms at least something that I've said before.
Sure.
That's good stuff. Any final words, Pete? I know we could talk a long time about this, but I think you've given a really good picture here for folks just to understand. There are risks, and quite frankly, Pete, this is why some landlords get out of the business because they run into a situation like this, or like it's not worth it. Any final notes here that you want to leave the listeners?
No, I would just say it is important to have an attorney. I know there are some clients that are finding leases online, and they say, well, I'll just use this and fill it out or something. And it's a little bit of time spent up front. It's the ounce of prevention versus a pound of cure comparison. Spend a little bit of time up front, make sure the lease is thorough, and there are no provisions that are going to cause a problem. And it's, it complies with Florida law, and it's as thorough as it can be. And I think that goes a long way. And when something comes up where a tenant is violating any term of the lease, I think you have to be very proactive and document it. Get letters out, document it so that at some point, if they come back, you're as well equipped as you can be to defend against something like what I've experienced here.
Yep, for sure. All great points, Pete. Well, listen, I'm going to respect your time today a little more than I have others in the past. I'm going to keep it at 30 minutes. So we're going to end the show now. So I really, really appreciate it, Pete. This has been great. I'm glad that you were here. And unfortunately, you had to go through this with your client. But you know what? That's what being an attorney is all about. It's helping your clients at the end of the day, right?
Absolutely. Right. That's what we do.
Yep. Well, maybe we'll talk again in the future if you have another really interesting case like this. Hopefully not, but if so, we'll talk about it in the future. So thanks again, Pete, for joining us.
Okay, great. Thanks.
All right, everybody, that'll do it for the show today. Thank you for watching and listening, and we will see you on the next episode. Have a great one.